a factory floor somewhere in industrial America, late in the 1930s. A worker has already put in what most people today would call a full day. The shift was supposed to end hours ago. But orders are up this week, the foreman needs more output, and the machines are still running, so the worker stays. Dinner is getting cold at home. The muscles are tired in the specific way that comes from standing at a machine for 10 or 11 hours straight. And there is a simple, practical question sitting underneath all of it. Is this next hour worth the same as the first hour of the morning, or is it worth something different? Nobody is handing this worker a contract to read or a government form to sign. The foreman simply says the line needs to keep running, and the worker either stays or does not. Whatever happens to the pace of this particular week, the household waiting at home still needs the same rent paid and the same food bought, regardless of how many hours it actually took to earn it this time. A modern viewer's instinct is to assume the answer is obvious. Extra hours mean time and a half. That is simply what overtime means. Set that assumption aside for a moment, because in this factory, in this year, that instinct does not automatically apply. There is no single federal switch yet that turns the worker's 11th hour into a different, more expensive kind of hour. That does not mean nothing governed this worker's hours. Some workers already had contracts that paid a premium for long days. Some states had hour laws covering certain trades. Some employers voluntarily paid more for extra time. What did not yet exist was one broad national federal rule that reached across state lines and told covered private employers the same thing about the price of a long week. The most surprising part of this story is not that America eventually created that rule. It is what the rule actually said. When Washington finally acted, it did not simply order this factory to send the worker home. It did something more interesting than that, and understanding what it did explains almost everything about how the modern American workweek actually works. To understand what changed, start with what this worker's hour 41 was actually worth before any of that existed. For many private industrial workers outside a union contract or a state hour law, that hour could be priced the same as hour 1 unless something specific said otherwise. A union agreement, an employer's own policy, or a limited state or federal rule that applied narrowly rather than nationwide. A worker belonging to a strong union in a well-organized trade might already have a contract guaranteeing extra pay past a certain daily or weekly point, because his union had won that specific concession at the bargaining table, one employer and one contract at a time. A worker in an unorganized shop in a town with more job seekers than jobs typically had no such document to point to and no leverage of his own to demand one. An individual worker could, in theory, simply refuse to stay past a normal shift. In practice, that refusal looked very different depending on circumstances. When jobs were scarce and a household needed every dollar of the weekly paycheck, refusing extra hours the foreman wanted could mean losing standing with a supervisor who controlled the next week's schedule entirely, or losing the job altogether to someone willing to stay. This was not because every employer was cruel or every worker was helpless. It was a structural fact about bargaining power. One worker, negotiating alone over one extra hour, rarely held much leverage against an employer who could reach into a large pool of other workers looking for the same job. That imbalance, more than any single bad employer, is the real starting point of this story. Americans had been fighting over the length of the working week for generations before any of this reached Washington in a durable way, and their first demand was not time and a half pay. It was simply fewer hours. The 8-hour day became something close to a movement slogan among 19th and early 20th century labor organizers, a demand repeated on picket lines and in union halls long before anyone was arguing about a specific dollar premium for hour 41. Some states did pass laws limiting hours for particular groups of workers, often women and children in specific industries, and some unions negotiated shorter days directly into their contracts, winning for their own members what no federal law yet guaranteed everyone else. But a single uniform national standard covering ordinary private employment kept running into the same wall, again and again, for decades. State rules could also draw surprisingly narrow boundaries. A law protecting women in a laundry in one state might say nothing about a man running a lathe across the state line, while a rule covering one trade could leave a comparable trade untouched. The patchwork mattered precisely because two workers doing exhausting work could face different limits simply because of occupation and geography. Garment workers in New York offer a concrete example of what organized bargaining could achieve without any federal law behind it at all. Unions in the needle trades had negotiated shorter standard weeks directly with employers years before 1938, proving that a 44 or 48-hour week was entirely workable in practice for at least some workers, in at least some cities, wherever a union had the bargaining strength to demand it and hold employers to the agreement. That wall was not simply stubbornness. It was a real economic problem. If one employer voluntarily shortened hours or raised labor costs while a competitor across the state line did neither, the reformed employer could find himself undercut on price by a rival running longer shifts at the same old rate. Workers wanted shorter hours. Employers who might otherwise have agreed feared being punished in the marketplace for agreeing first. That competitive problem helps explain why local and voluntary solutions could improve particular workplaces without creating a uniform national floor. Then the Great Depression arrived, and it turned a decades-old argument about fatigue into an entirely different and much more urgent argument about jobs. By the early 1930s, unemployment had climbed toward a quarter of the American labor force, while some employers who still had orders to fill found it cheaper and simpler to keep their existing employees working long weeks, rather than hire additional people and train them from scratch. A factory could be running its current workers 60 hours a week while men outside its gates stood in line for any opening at all. Think again of the worker from the opening scene, only now picture him a few years earlier, in the depths of the Depression itself. He still has a job, which already makes him fortunate compared to millions of neighbors who do not. But his employer, rather than hiring 2 or 3 more men from the line outside the gate, finds it simpler to keep running him and the rest of the existing crew longer hours instead. Since training new workers costs time and money, the factory would rather avoid. Reformers began arguing that shorter standard hours, paired with some kind of penalty for excessive overtime, could push in the opposite direction. It could make it more attractive, at the margin, for an employer to bring on another worker, rather than keep squeezing more hours out of the workers already on the floor. This was presented as an incentive built into the price of labor, not a guarantee that one new law would create one new job for every hour cut. Roosevelt's administration first tried a version of this idea through the President's Reemployment Agreement in 1933, asking employers to voluntarily sign on to shorter hours and minimum pay in exchange for a public symbol showing they were cooperating with recovery. The broader National Industrial Recovery Act pushed the same logic further, encouraging entire industries to adopt formal codes setting hours, wages, and other standards specific to their trade. The Cotton Textile Code became one of the most cited early examples. It set a 40-hour week for an industry that had often run its mills far longer than that, established minimum weekly wages, and banned child labor on the factory floor. The point for this story is that Washington was already experimenting with shorter standard weeks before the FLSA existed. But the NRA's underlying legal structure rested on a broad reading of federal power that the Supreme Court was not willing to accept. In 1935, in a case involving a poultry company, the court struck the NRA framework down, ruling that Congress had reached beyond its constitutional authority in the way it had delegated code-making power across the economy. The reform Roosevelt's administration had leaned on hardest was suddenly gone, and the underlying problem it had been trying to solve had not gone anywhere. For a moment, the project stalled. The codes that had set hours and wages across many industries stopped being enforceable. Reformers inside the administration now faced a harder question than before, not just what a national labor standard should look like, but what kind of standard Congress could write that would survive the next constitutional challenge. Washington needed a labor standard that could survive both the political fight in Congress and a much more skeptical Supreme Court, and it needed proof that the federal government could act at all in this space without repeating the same constitutional collapse. The next attempt was narrower by design, built to demonstrate the idea on a smaller, more defensible piece of ground before anyone tried the broad version again. That narrower attempt used a tool the federal government clearly did possess, its own purchasing power. In 1936, Congress passed the Walsh-Healey Public Contracts Act, which required companies selling goods to the federal government under covered federal supply contracts to meet specific labor standards, including an 8-hour day and a 40-hour week for the workers producing those goods. The logic was different from the NRA's. Washington was not telling every private company in America how to run its factory. It was setting labor conditions on certain purchases made by the federal government itself. A company that wanted covered government business had to meet those terms. A company outside that sphere did not. Walsh-Healey did not touch the worker at that opening factory floor if the company had no government contract at all. Its reach was limited strictly to firms doing business directly with Washington, but it mattered enormously as a demonstration. It showed that the federal government could attach labor standards to economic activity it touched, and that a shorter, defined workweek could be written into federal policy without the whole structure collapsing in court the way the NRA had. The next fight was over something much larger: whether Congress could build a broad national wage and hour rule reaching private employment connected to interstate commerce, not just the narrow slice of companies selling directly to the government. That fight consumed much of Roosevelt's second term, and it was genuinely contested every step of the way, not a foregone conclusion once reformers decided to pursue it. Labor Secretary Francis Perkins had been pushing for broader wage and hour legislation for years, and Roosevelt himself had held back a comprehensive bill for a time while fighting other battles, including his unsuccessful effort to reshape the Supreme Court. Business groups worried openly about federal reach into local labor markets, about compliance costs, and about losing the flexibility to run their own operations without a Washington inspector checking their hour records. These concerns were not simply cover for greed. A small manufacturer operating on thin margins faced a different calculation from a large corporation that could absorb new labor costs more easily, and competitors worried that a national standard could change regional and industry advantages. At the same time, a national floor had one feature local reforms did not. It would bind covered interstate competitors to the same federal baseline rather than leaving one firm to move first. Organized labor did not speak with one voice either. Some unions worried that a national wage and hour floor, set by federal administrators, could undercut hard-won local contracts that already exceeded whatever minimum Congress might eventually settle on. Southern legislators, representing a region with generally lower industrial wages, pushed back hard against a single national wage floor that they feared would erase a regional cost advantage their local employers depended on. The bill that finally moved through Congress in 1938 was heavily negotiated and repeatedly modified before it reached the president's desk. Even its final form was a compromise among lawmakers, labor groups, employers, regions, and an administration still thinking about what the courts would permit. President Roosevelt signed the Fair Labor Standards Act on June 25, 1938, and it took effect that October. Here is the reversal a modern viewer rarely expects. The famous federal law did not cover the whole American workforce on day one. In its final form, it applied to industries whose combined employment represented only about 1/5 of the country's labor force, reaching interstate commerce and the production of goods for that commerce rather than every job in the country. Millions of American workers did not wake up under this new rule at all. Agricultural workers were excluded from its central provisions. So were many workers in service occupations, in smaller local businesses that did not touch interstate commerce, and in a range of other categories the statute specifically carved out. The famous national law, at its founding moment, was narrower than its reputation suggests. For the workers it did reach, though, the law contained a mechanism worth slowing down for, because this is the actual intellectual center of the entire story. Section 7 of the Fair Labor Standards Act did not say that a covered worker could not be kept on the job past a certain number of hours in a week. It said something different and, in a quiet way, more clever, it changed what those extra hours cost the employer. During the law's first year, any hour a covered worker spent on the job beyond 44 hours in a single week had to be paid at not less than 1.5 times that worker's regular hourly rate. In the law's second year, that threshold dropped to 42 hours. After the second year expired, it dropped again to 40 hours, the number that has stayed in place as the federal overtime line ever since. The phase design was itself a compromise. The important point for the worker is practical. The modern 40-hour line did not arrive on the first day. Employers first adjusted to a 44-hour threshold, then 42, and only after the second year to 40. So the federal standard moved toward its familiar form in stages rather than overnight. Notice what the law did not do at any of those three stages. It never said the 41st, 43rd, or 45th hour was illegal to work. A covered employer could still run the shift beyond the threshold. What changed was the price tag attached to those particular hours once the weekly line in effect that year had already been crossed. It is worth being precise about one more detail here, because it is easy to blur two different ideas. The statute measured hours across the whole week, not against any fixed daily limit. A covered worker could, in principle, put in a very long single day without triggering the premium, so long as his total hours for the week stayed under that year's threshold. The federal overtime rule was a weekly calculation built around the work week as a whole, not an automatic penalty for any single day that ran past 8 hours. Picture the arithmetic from the employer's side once the 40-hour threshold was fully in place. A worker earning some ordinary hourly wage now costs that employer 1.5 times as much for every hour past 40 in that week. Multiply that premium across a whole shift of workers being held late every week, and the calculation an employer had once made almost automatically now had a real cost attached to it that had not existed before. To make this concrete with a purely illustrative round number, imagine a covered worker earning 60 cents an hour. Every hour up to the statutory threshold cost the employer that same 60 cents. Every hour passed, it now cost 90 cents instead, a 50% jump on exactly the hours an employer was most tempted to lean on when an order needed to ship by Friday. That single change reshaped the employer's decision at the margin. Keep the same crew working long hours and absorb the overtime premium. Reorganize the shift schedule to spread the work differently, add a second shift, or bring on another worker and compare that cost against the price of the premium hours. None of these choices was mandated by the statute. The law simply made one option: running people very long cost noticeably more than it used to. An employer weighing these options was not choosing between good and evil. He was doing ordinary business arithmetic, now with a new number in the equation that had not existed before October of 1938. If hiring and training another worker cost less than paying the existing crew time and a half indefinitely, the premium pushed the calculation toward spreading available work, one of the purposes Congress attached to the overtime rule. For the worker still asked to stay late under a covered job, something changed too, even if the schedule itself did not. The paycheck for that week now reflected a higher rate on every hour past the statutory line, not because the boss had become more generous, but because federal law now required it as the price of using that worker's time beyond the threshold. This is the core bargain worth holding onto for the rest of the story. America did not, through this law, simply forbid the long week. It built a price into the long week. For a covered worker, the extra hour stopped being an ordinary rate hour and became deliberately a more expensive one, both for the employer paying it and, when it still happened, for the worker's own weekly pay. That distinction also explains why the law used a premium instead of simply making every hour beyond the threshold illegal. A flat prohibition would have removed employer flexibility even when production genuinely demanded a longer week, and it would not by itself have told the employer what a necessary extra hour should cost. The premium took a different approach. It preserved the option to work longer, discouraged very long schedules by raising their marginal cost, and gave the covered worker extra compensation whenever those hours still occurred. It would be a mistake to walk away thinking this new bargain reached every American worker equally, because it plainly did not, and the exclusions were not minor footnotes. Agricultural labor, one of the largest categories of American work at the time, sat outside the Act's core wage and hour protections from the beginning, a carve-out that would shape debates over the law for decades afterward. Many domestic workers, many employees of small local businesses that did not engage in interstate commerce, and a range of specifically exempted occupations also fell outside the statute's reach at first. Put two workers side by side in 1939, one on an assembly line shipping goods across state lines, now covered by the new federal threshold, and another doing comparably demanding work that the statute simply did not reach at all. Picture a farm worker and a factory worker living in the same rural county that autumn. The covered factory worker, producing goods that would ship across state lines, could now expect a federal overtime premium once his week crossed the statutory threshold. The farm worker, doing equally exhausting labor a few miles away, received no federal overtime premium from the new act because agriculture was outside that requirement. The federal standard, in other words, was national in its architecture, but not universal in its coverage. Later amendments gradually expanded who the law covered, but that expansion took years and then decades, not a single stroke of the president's pen. Even for workers the law did cover. The new system did not eliminate conflict over hours. It relocated that conflict onto a new set of questions. Once pay depended on precisely how many hours a worker had worked in a defined week, employers needed real records, and disputes increasingly turned on definitions: what actually counted as compensable working time, how to calculate a worker's true regular rate when pay included bonuses or other extras, and whether a particular job qualified for one of the statute's exemptions at all. The statute also exempted bona fide executive, administrative, and professional employees from its overtime requirements and left the Labor Department to define those categories in regulation. That created another durable question the old system had not posed in the same way: which workers belonged inside the premium pay rule, and which jobs genuinely fell outside it because of the work they performed. Before 1938, the recurring argument at a workplace like this one had mostly been about whether the boss would agree to pay anything extra at all for a long week. After 1938, for a covered job, the argument shifted toward narrower, more technical ground. Had this particular activity actually counted as time worked under the statute, and had the employer calculated the regular rate correctly before applying the required premium on top of it? To administer and enforce the new system, the 1938 law created the Wage and Hour Division inside the Department of Labor. Its job was not merely to announce a 44-hour threshold and walk away. A federal overtime right required records, investigations, interpretations, and a way to pursue employers that failed to pay what the statute required. The reform had moved much of the conflict from custom and individual bargaining toward law and enforcement. The law also still had to survive one more serious threat, the same kind of constitutional challenge that had destroyed the NRA only a few years earlier. Critics argued Congress had no more authority to regulate wages and hours inside a lumber mill or a garment factory than it had possessed to run the NRA's industrial codes, and the memory of 1935 hung over every year the FLSA operated before the question was finally settled. In 1941, the Supreme Court took up a case involving a Georgia lumber company that had challenged the law's authority to regulate wages and hours for workers producing goods that moved in interstate commerce. And this time, the court upheld the Fair Labor Standards Act unanimously, removing the doubt that had shadowed federal wage and hour law since the NRA's collapse in 1935. With that constitutional question settled, the framework built in 1938 became durable rather than provisional. The specific dollar figures and hour thresholds would be revised repeatedly over the following decades, and the categories of covered work would expand well beyond that original 1/5 of the labor force. But the basic mechanism Congress had built, pricing the extra hour rather than banning it outright, remained the architecture underneath every later adjustment. That durability is easy to take for granted from the present. A rule that had been fought over for decades, tested through a failed constitutional experiment, and preceded by narrower federal measures eventually became so ordinary that most workers today never think to ask why the 40th hour is treated differently from the first. Return, finally, to that worker still standing at the machine as the ordinary shift ends and the extra hours begin. Before this federal system existed, whether that next hour paid anything different from the first hour of the day depended on a patchwork of contracts, state laws, and employer habits that reached some workers and missed most others entirely, with no single national floor beneath any of it. After the federal system matured into its familiar form, a covered non-exempt worker, crossing 40 hours in a week, was generally no longer working an ordinary priced hour. The boss could still schedule or request more time. Nothing in the statute made a long week itself illegal for an adult worker in an ordinary covered job. What the law changed was what that extra hour cost. The worker gained a federal premium for covered overtime and a stronger price signal attached to very long weeks, arriving through the same paycheck as always but calculated differently now. The employer kept the ability in many circumstances to use overtime when a real order demanded it, but had to internalize a genuinely higher labor cost for those particular hours, a cost that had simply not existed on the books before October of 1938. For the household waiting at home, the practical difference showed up in a place that mattered more than any statute or court case: the total at the bottom of the pay envelope on a week when the shift had run long. That number was no longer simply hours multiplied by the same old rate. For a covered worker, the federal overtime premium was now built directly into the arithmetic. America did not end the long work week in 1938. It changed the contract attached to it. The extra hour could still be worked. The law did not make the long week itself illegal. For a covered worker under a system that phased from 44 hours to 40, that hour simply stopped being priced like all the ordinary hours that had come before it.